Good evening. Thank you for joining us for our Eye on Asia webinar series. We are glad to have about 90 attendees with us today from Singapore and beyond. Before we start, please allow us to run through some housekeeping to ensure that everyone can enjoy this session. Once our program starts, you'll be muted with your video function off. These are the sample screens on how the chat and Q&A functions would look like on your screen. Tap on the three dots and you should see a text box appear. And to return to the presentation slide or speaker video view, click close at the top left corner of your screen. Please post your questions using the Q&A function, which we will address during the Q&A segment after the speaker's presentation. Today's topic is managing and protecting intellectual property in Asia, recent developments in India. We are happy to have with us this evening Mr. Kaushik Bora, who is a contract and rights manager at McGraw Hill Education. He is an experienced lawyer admitted to the Indian bar and has been working in Singapore for the last 8.5 years. He has experience in both private practice and in an in-house role, covering multiple jurisdictions across Asia Pacific. McGraw Hill is one of the world's leading publisher and education technology companies, and Kaushik is currently working with the Asia Pacific segment, where he handles IP-related contracts, rights management, and various other legal matters. Now, focusing on ASEAN countries, China and India, Eye on Asia is a collaborative effort by the National Library Singapore with partners to provide resources for Singaporeans who wish to find out more about the region and explore internationalization opportunities abroad. I'll now pass the session to Kaushik. Over to you, Kaushik.
Thank you, Ashif. Hello, everyone. Again, so today I'm going to present on this topic, managing and protecting intellectual property, recent developments in India. Before I start, I just want to make it clear that this presentation is meant for informational purposes only. This is intended to help viewers understand the basics of intellectual property and to provide an overview of the IPR regime in India. IP laws are complicated. There are different laws for different types of IP, and it also differs from country to country. So the information herein are not complete and exhaustive. If you need any legal opinion or detailed information about any aspects of IP or IP laws, please take independent legal advice. Now, I'm going to tell you about the topics that we'll cover during this session. So today I'll cover the following. First of all, I'll provide an overview of intellectual property, the basic concepts, definitions, and types of IP. Then I'll move on, deep dive a bit into commercialization of IP, giving an example from the publishing industry. Thirdly, I'll walk through some of the international IP treaties or conventions for protection of IP. Fourthly, I'll discuss an overview of Indian IP regime and also some of its policies and recent developments. Lastly, I'll discuss some of the similarities in the IP laws of India and Singapore and share some statistics with you. Thereafter, I'll conclude my session and open the floor for Q&A. In between, I'll also tickle your brain with some polling questions, some multiple choice questions to ensure that you do not fall asleep. Let's start with the basics first. So what is an intellectual property? Although I am sure everyone is generally aware of these concepts, since IP is omnipresent in our day-to-day lives. So if in layman terms, you have to define intellectual property, it is an original creation of human intellect or human mind. IP can be created in various forms. I'll talk about some simple instances in the next slide. If I invent something new, such as telephone, an IP is created in the form of a new product. If I write a new book, an IP is created. If I design a new car model, an IP is created. If I create a new logo, an IP is created. If I click a photograph, an IP is created. If I compose new music, an IP is created. So you can see that there are different ways of IP creation. Actually, what type of property is an IP, is an intellectual property? Properties are broadly categorized into two types, tangible and intangible. IP is an intangible property. Examples of tangible properties are house, car, laptop, etc., which can be touched physically. But IP is an intangible property with characteristics which are similar to a tangible property, such as an IP can also be sold, it can be bought, it can be leased or rented, it can be gifted under a will, it can be assigned as well. So you can see that like a tangible property, intellectual property also enjoys certain legal ownership rights. Now, What are intellectual property rights, or in short, what is IPR? In simple terms, intellectual property rights are like any other property right. They recognize and grant ownership and other legal rights to creator of IP. For example, when you buy a house, you have the right to use the house or have control over the use of the house. Similarly, when you create an IP, you have the right to use it or control its use at your discretion. IP rights are granted to the creator, who enjoys certain rights over the IP. In other words, when you have IP rights, it prevents others from copying, distributing, exploiting, or otherwise using the IP without the authorization of the creator. Next, why should we promote IP rights? So there are definitely a lot of benefits of IP rights. IP rights help to maximize the opportunities for appropriation while minimizing the risk of free riding. In other sense, they allow creators to benefit from their own work or from their investment in a creation. An equitable IPR system can help countries to realize full potential of IP, and it can act as a catalyst for socio-economic development and cultural well-being. The IPR system helps to strike a balance between the interest of the innovators, those are the creators, the owners, and the public interest, providing an environment in which creativity and invention can flourish for the benefit of all. Now, before moving on, we'll do our first poll. So I'm going to ask my team to display the poll question. So we'll give around 30 seconds. Request all of the viewers do the voting. Okay, I'm going to end the poll here. So yes, so the question was that, let's assume that you bought a car. When you bought the car, did you acquire ownership of any intellectual property in the car? The answer is no. And most of the result shows that 75% actually chose no, which is the correct answer. So car is an intangible, it's a tangible asset, right? It's a tangible property. When you buy it, you acquire ownership over the car as a tangible asset. However, the intangible assets or IP in the car, which could be the design of the car, any patented equipment or technology inside the car, the logo of the car, all these are IP which are owned by the car making company. This IP are not transferred or sold to you when you bought the car. Now let's move on to the next slide. What are the different types of IP? IP may be broadly categorized into two types: copyright and industrial property. Copyright and its related rights are one type of its own. Under industrial property, we have a few different types of IP, such as trademark, industrial designs, patent, geographical indications, trade secrets. Now I'll briefly touch each of these concepts. First of all, what is copyright? Copyright is a type of IP right that protects an original literary, dramatic, musical, artistic, or other eligible creative work. Originality is a prerequisite for copyright protection. And also the idea or concept must be expressed in tangible form to get copyright protection. Some items of copyright protection are books, movies, music, art, photograph, audio recordings, etc. Moving on to patent. What is patent? A patent is a right granted to the owner of new inventions, for example, a new product, a new process, materials, composition. It also protects any new and useful improvement of an existing invention. There are different criteria to get a patent. A few common ones are, it must have new characteristics, it must be an inventive step, and it must be useful. That means it should be practical and it must have industrial applicability. Patented inventions touch every aspect of human life, from electric lighting all the way to the iPhone. All of these are patented. Once a patent expires, protection ends and the invention enters into the public domain. Moving on to the next one, which is geographical indication. A geographical indication is a distinctive sign that is used to identify a product as originating in a particular country or locality, and its quality, reputation, or other characteristics are linked to its geographical origin. Some examples, such as Scots whiskey from Scotland, Darjeeling tea from Darjeeling in India. Next is industrial design. An industrial design refers to the ornamental or aesthetic aspects of an article or product, the way it looks and feels. It only protects those aspects of a product that are ornamental, which means that its technical features may be protected by patent, but not under industrial design, if they meet the requirements for patent protection. A design may consist of three-dimensional features, such as the shape or surface of an article, or two-dimensional features, such as patterns, lines, or colors. Moving on to the next IP is trade secrets. Trade secrets are basically confidential business information by which an enterprise or a company can obtain an economic advantage over its competitors. For example, a secret method of manufacturing, customer information, trade volume, a secret recipe. These are some of the examples. Arguably, the most famous example of a trade secret is the Coca-Cola recipe, which has been closely guarded by the company for over 100 years. Moving on to the next IP is what is a trademark? A trademark is a distinctive sign that identifies certain goods or services produced or provided by an individual or a company. Trademarks may be one word, or it could be a combination of words, letters, and numerals. All sorts of signs may be used as trademarks. Words, letters, numbers, symbols, colors, pictures, etc. In some countries, non-traditional marks may be registered, such as three-dimensional signs like shapes and packaging, holograms, sounds, even taste and smells are also being registered as trademark in some of the countries. Some examples of trademark, the McGraw Hill logo. You can see the words McGraw Hill, that is trademark, as well as the entire logo is also trademark. Other than that, in our day-to-day life, we can see a lot of products which have been trademarked: Coca-Cola, KFC, Lego, BMW. These are some of our day-to-day trademarks that we come across. So far, we have covered intellectual property overview. Now we are going to talk about the significance and commercialization of intellectual property. And I'm also going to give you an example from copyright in publishing industry. But before, let's do a quick poll. Okay, so can there be multiple overlapping intellectual property rights existing in one product? That's it. Okay, so I think most of the people got it right. The answer is yes. Let's take the example of Coca-Cola. The logo of Coca-Cola is an example of trademark. Shape of the bottle, it can be registered as an industrial design, which is another IP. Patent may have been obtained in respect of bottling the equipment. That could be patented. Copyright in respect of the advertisement and artistic work that goes together with Coca-Cola advertisements. Trade secret is the Coca-Cola recipe. So you can see that in a single product, there could be more than one IP. Now moving on, let's talk about significance of IP. Why is IP so significant in the business world and in today's innovative world? Intellectual property helps to drive business opportunities. IP is an asset, not a liability. It gives protection against competitors, prevents them from using or copying your IP. It helps you to create a unique brand identity for your product or your company. It enhances your company's valuation and helps in customer acquisition and also attracting investors. It enhances research and development and collaboration work with other third parties. It provides various sources of revenue through commercialization. IP has so much significance in today's competitive world. Let's talk about commercialization of IP. What do you generally mean by commercialization? Commercialization of IP generally refers to extracting value from the IP by marketing a new product or service based on the IP entirely or partly. It is typically a journey of many steps and business models that will ultimately help you to earn revenue. Commercialization depends on many factors. For example, it depends on the type of IP, whether it's a patent, whether it's a trademark, whether it's copyright. It also depends on business capabilities, your resources, the size of your team, the production capabilities, etc. Competitive environment, yes, the market scenario and what your competitors are providing. And lastly, access to finance. How deep is your pocket? Now let's look at commercialization of IP in the publishing industry. Let's go through an example of commercialization in the publishing industry. So what is the most important IP for a publishing company? Copyright. That's right. Copyright is the most important asset. We have already discussed the definition. So one important point about copyright is that it is a bundle of rights, not a singular right, which means that there are more than one right which is inside a copyright. So let's unbundle the copyright. The creator or the copyright owner is entitled to a bundle of exclusive rights, such as the right to reproduce or make copies of the work, the right to distribute copies of the work, the right to create a derivative work or many derivative works, the right to communicate or broadcast the work publicly, the right to perform the work publicly. So these are all the rights that are inside the bundle of rights of copyright. How do you protect these rights? In most countries, you do not need to register copyright to get protection. In Singapore and India, similarly, there is no need to register copyright for obtaining protection. Automatic protection is granted as soon as any original work is expressed in tangible form. So what happens if someone exercises one of those rights from the bundle of rights without the copyright owner's permission or consent? It amounts to copyright infringement. That's right. If any of the exclusive rights granted to the copyright owner is exercised by another person without the permission or consent of the copyright owner, it amounts to copyright infringement. Copyright infringement allows the copyright owner to take legal action against the infringer or the pirate. They can take civil action as well as criminal action. Now let's understand how a literary work can be commercialized legally or without infringing creators or the rights owners' rights. Generally, in a publishing world, when a work is created, it belongs to the creator, that is the author. The author is the first owner of copyright. So the author, being the first owner, owns the right, the bundle of rights in the work that they have written. They transfer all or some of the copyright. As I just said that it's a bundle of rights, so they can transfer all or some of it to the publisher. Then the publisher will publish the work in various formats, whether it's print, electronic, audio, etc., depending on the contract with the author. What happens next? Once the work is published, publisher uses its branding to promote. The publisher distributes the work to channel partners or to customers directly. Publishers usually have different networks and contacts for exploiting the different layers of rights within the work. Publisher enters into various contracts to further commercialize the IP. Licensing is a major tool for copyright commercialization. It is one of the primary methods to earn revenue. Copyright license can be exclusive or non-exclusive. License agreements should be generally in writing to specify the scope of the license and the scope of the rights that are granted to the licensee. The ownership of rights should be specified because there is a background IP that goes into it as well as the foreground IP that is produced. There is also a need to specify the fee or the royalty structure. Publisher can license some of these rights. For example, translation rights to meet local translation requirements, adaptation rights to meet local academic standards, film rights, audio rights, and they can also allow others to use excerpts in another work through which they can get a permission fee. So they earn revenue from all these different licensing models, which are then received and shared with the author based on the contract. As you can see from the sale of the work, licensing of the intellectual property rights through collective licensing using CMOs, that's collective managing organizations, there is revenue received from sale and all these different models. And then the revenue is then shared between the author and the publisher based on their contract. This is a simple example of how you can commercialize and earn revenue from copyright. Other than this, there are different other models or business models that can be used to commercialize and benefit from IP. Some of these are, we already discussed licensing, assignment, franchising, through mergers and acquisitions, through joint ventures. Through proper IP management, you can find different revenue streams. So far, we have discussed the first two topics, that is the intellectual property overview, significance and commercialization. Now we'll move on to IP protection. At this point, we'll do another poll. So if you share your idea about the plot or the storyline of a book with someone verbally, your friend or anyone, and the other person uses it and expresses it in tangible form, can you make a claim of copyright ownership? So we have 79% saying no, which is the correct answer. Copyright is protected only when the idea is expressed in a tangible form. So if you share your idea with someone else and the other person expresses that idea in a tangible form, the second person will be the copyright owner. Of course, if you have signed a non-disclosure agreement or if you have shared it as a trade secret, it's a different scenario. But generally, you would not have any copyright protection for the idea that you came up with. Moving on, let's talk about protection of intellectual property. What is it? Just like a bank protects your money against theft, intellectual property rights protect your intellectual creation against theft. The state and its legal system confers such protection. Obviously, IP protection plays an important role in IP commercialization and it further enhances IP creation. Let's look at some of the IP protection systems that are in place. Let's discuss about the international IPR regime. International treaties and conventions provide a robust framework for IP protection globally. Due to the increasing importance of IP and its impact in every aspect of human society, there are international treaties and conventions being held and entered into from time to time. These international treaties help the individual countries to formulate consistent policies and laws for protection of IP in their respective countries. Let's see what are some of the principles and goals of international treaties. The international conventions or treaties lay down the minimum requirements for the member states to legislate and pass laws for IP protection. These treaties are signed between different countries, not between individuals. Important principles are established and encouraged for the member countries to implement international laws. The ultimate goal is to have a stable IP protection regime locally as well as globally. Let's go through some of the important conventions and treaties related to the IPs that we have just discussed. First of all, TRIPS, trade related aspects of intellectual property rights. It was signed in 1995. It is one of the most comprehensive multilateral agreement on intellectual property. It is an international agreement between all the member nations of the World Trade Organization. This agreement covers copyright, trademark, industrial designs, patents, geographical indications, and undisclosed information, including trade secrets. This is a minimum standards agreement which enables member countries to provide a more extensive protection of intellectual property. Moving on, next we have the Paris Convention. It was adopted in 1883 and entered into force on July 7, 1884. Under this treaty, any person from a member state or a signatory state can apply for a patent or trademark in any other signatory state and will be given the same enforcement rights and status as a national of that country would be. This convention provides basic guidelines for the protection of industrial property relating to patents, industrial designs, trademarks, and it also has substantive provisions for national treatment, right of priority, and common rules. Berne Convention is one of the most important one in relation to copyright. It was adopted on September 9, 1886 at Berne. This convention establishes three basic principles, namely national treatment, automatic protection, and independence of protection. So I can briefly touch on these three principles. So first of all, national treatment. Each member state recognizes the copyright of authors from other member states in the same way as the copyright of its own nationals. Basically, not making any discrimination between foreign nationals and its own nationals in terms of copyright protection. Second, automatic protection. Protection must not be conditional upon compliance with any formality. So that is the principle of automatic protection. Lastly, independence of protection. Protection is independent of the existence of protection in the country of origin of the work. So even though in the country of origin of the work, even if it is not protected, it doesn't mean that it will not get protection in the foreign country. It has to be independent of the existence of protection in the country of origin. Let's move on to Patent Cooperation Treaty, PCT. So as the name suggests, this is in relation to patent cooperation protection. It facilitates patent protection for an invention simultaneously in its member countries. This provides for the filing of a single international patent application that has the same effect as national applications filed in the designated countries. This is a central system for obtaining a bundle of national applications in different jurisdictions through a single application. Madrid system. It is a convenient and cost-effective system, or you can say solution, for registering and managing trademarks worldwide. Under this, a person can file a single trademark application at their national office that will provide protection in multiple member countries. You need to fulfill certain criteria, such as you need to have a personal or business connection to one of the Madrid system's members. All these international conventions you'd see provide the framework or minimum standards for countries to implement and adopt into their national laws. So let's look at country legislation. So IP legislation has developed rapidly, and countries try to build on best practices from other countries as well as from the international conventions. Each country continues to build a reputable ecosystem through national legislations. The Singaporean IP legal framework is a very comprehensive and generally considered to be one of the most sound in Asia as well as globally. It has implemented laws to recognize and protect and enforce all the different types of IP. Some of the laws of Singapore are like Copyright Act, Registered Designs Act, Patents Act, Trademarks Act, Geographical Indications Act, Trade Secrets, which is also covered under the Copyright Act. So far, we have discussed the first three topics, and now we are going to move on to the Indian IPR regime. But before that, we are going to take our next poll question. Trade-related aspects of intellectual property rights TRIPS agreement covers which of the following intellectual properties? Copyright, patent, geographical indications, trademarks, all. Yes, so here is the polling results. I can see 94% have voted E, that is all of the above, and that is the correct answer. So as I said, TRIPS is one of the most multilateral agreement which covers all the intellectual property rights. Let's talk about intellectual property rights in India. The government of India approved the National Intellectual Property Rights Policy on 12th May 2016. This policy contains or consists of the future roadmap for IPR in India. While India has always been an innovative society, much of the intellectual property created remains unprotected because of two reasons. One is lack of awareness, and secondly, the perception that IP protection is either not required or it is unnecessarily complicated. So, the rationale for the national IPR policy lies in the need to create awareness. It's about the importance of IPR as a marketable financial asset and economic tool. This new policy is aimed at enhancing socio-economic, cultural development and promoting entrepreneurship in all scales. The Department for Promotion of Industry and Internal Trade, the DPIIT, shall be the main point to coordinate, guide, and oversee implementation and future development of IPR in India. There are seven main objectives adopted in the new IPR policy. I'll not discuss all of the seven, but I think the three most important objectives are to create public awareness about economic, social, and cultural benefits of IPRs among all sections of the society. The second one would be to stimulate generation of IPRs. The third one would be to strengthen the enforcement and adjudicatory mechanisms for combating IPR infringements. So these three out of the seven are the most crucial ones. So what are the steps that are taken by the government under this new IPR policy? They have set up this professional body called CIPAM, the Cell for IPR Promotion and Management. It commenced its work in 2017 and it covers pan India. Some of the highlights of steps taken by this committee are as follows. They set up 4,000 IP awareness workshops, seminars in academic institutions and the industry across India. They did a lot of workshops with eminent international speakers on IP in the global context. They had 270 IP training programs for enforcement agencies and judiciary. So it would mean the police and the judicial staff. Modernization and strengthening of IP Office is another national level scheme implemented by the government. It was implemented in 2008. The chief objective of the scheme is to strengthen the capabilities of the intellectual property offices in India. This also goes towards implementing one of the objectives of the new IPR policy. The government has also set up IP facilitation centers across the country. So some of the general work done by these IP facilitation centers are providing information on any intellectual property, helping people to check patent status, drafting, filing of applications, providing opinion on the likelihood of getting application accepted, guidance on IP technology mapping, and infringement analysis and opinion. Other than that, the government has also given assistance to startups and MSMEs. So MSME would be basically micro, small, and medium enterprises. The government has given rebates in the IPR fee for those MSMEs and startups. There is also professional services through panel attorney and IPR consultants, which are either free of cost or it's reimbursed by the government of India. You can visit these sites, startup.gov.india for more information about startup in India. And you may be interested in registering or starting companies in India, which you can find information in those links, which I can provide to you after this session. Now let's look at some of the legal and legislative framework that exists in India. India has a long history of IP laws, which have evolved taking into consideration national needs and also international commitments or through those international conventions and treaties that India has entered into. The existing laws were either enacted or revised after the TRIPS agreement, which is one of the most comprehensive multilateral agreement, and are fully compliant with it. These laws, along with various judicial decisions, are meant to provide a stable and effective legal framework for protection and promotion of IPRs. The recent developments and changes in India's intellectual property laws clearly reflect the importance accorded to IPR. So some of the acts that are existing in India related to IPR are the Trademarks Act, the Patents Act, the Copyright Act, the Designs Act, and last but not the least, the Geographical Indications of Goods Act. Let's talk about a few legislative changes which are important and which are being currently in the process of being made by the government. The government released a draft national e-commerce policy, which recommends that e-commerce platforms be mandated to undertake certain anti-counterfeiting and anti-piracy measures. This is an important step, but so far this bill has not been approved, so it's still under discussions. There have been changes made to the copyright amendment rules, which are meant to ensure smooth and flawless compliance of Copyright Act in the light of technological advancements in the digital era and bring them in parity with other relevant legislations. That copyright amendment rules also proposes to the Cinematograph Act 2019. That bill proposes to criminalize unauthorized use of an audio-visual recording device for making or transmitting a copy of a film or any part of it with a punishment of 3 years of imprisonment or a fine of 10 lakh rupees or both. So this is also an important step taken by the government in making those legislative changes. There are also some notable judgments which have come in the recent times and which are important for the intellectual property regime. First of all, the TIPS Industries versus Wing Music Limited and others. This is related to copyright. It was decided that online streaming services are not eligible for statutory licenses under the Copyright Act. The second case, Make My Trip Private Limited versus Make My Travel India Private Limited, is actually about use of a trademark in which the original trademark owner was given protection by the court, which is Make My Trip. The third case is about infringement of copyright over a cinematographic film. It has been decided that making a deceptively similar or unauthorized remake was a violation of the copyright in the cinematograph film itself. That's considered as a landmark case in India. Now let's talk about enforcement of IP rights in India. To enjoy most types of IP rights in India, you should try to register them in India. India's IP laws set out procedures for both civil and criminal proceedings. IP rights can be enforced by bringing actions in the civil courts or through criminal prosecution. But criminal prosecutions do not apply to patent and design infringements. So it applies to copyright as well as trademark. In civil cases, damages are awarded or compensation are awarded in cases of copyright and trademark infringements. And over the recent years, decisions in favor of foreign companies against local infringers have demonstrated the judiciary's impartial approach. As in other countries, the Indian government also brings actions in criminal cases, although in most cases, actions follow complaints to magistrates or police authorities by the copyright holder or the rights owners. Due to cost and time factors, sometimes mediation and negotiation may provide a swift result. So you really need to decide what would be the best option for you if there is infringement of your IPR in India. So far, we have discussed the first 4 items, and then we're going to move on to discuss about Singapore and India similarities and statistics. But before that, we're going to have our last question, MCQ. What is the first and foremost objective of National IPR Policy of India 2016? So I can see that 66% answered IPR awareness, which is the correct answer. The most important objective is creating awareness amongst the different sections of the society. And this is actually one of the important objective for WIPO and other world organizations as well. Now, let's see what are the international treaties or conventions that have been signed by Singapore and India. So we can see that the TRIPS agreement was signed by both India and Singapore in 1995. The Berne Convention, which is related to copyright, was signed by Singapore in 1998, while India signed it in 1928. The Paris Convention for Industrial Property Protection, it was signed by Singapore in 1995, and India signed it in 1998. So we have Singapore PCT was signed in 1995 by Singapore and in 1998 by India. Madrid Protocol was 2000 and 2013 in India. Then Hague Agreement was signed in 2005 by Singapore, and India has not signed this Hague Agreement yet. Let's do a quick comparison of intellectual property rights laws, India and Singapore, in terms of duration of IP protection. So you can see copyright, it's life of the author plus 60 years in India, while in Singapore, it's life of the author plus 70 years. Patent, it's the same. It's 20 years for both India and Singapore, but in India, you have to renew after every year. In Singapore, you have to renew only before the expiry of the 4th year, but thereafter you have to renew every year. Trademark, it's the same 10 years from the date of registration, and then you can keep renewing it for further periods of 10 years. Design, you can see it's 10 years from the date of registration in India, and then you can renew for another 5 years. In total, it's 15 years. In Singapore, you can get 5 years protection from the date of registration, and you can renew another 2 times of 5 years each. So in total, it will be 15 years as well. Geographical indications, it's 10 years from the date of registration and renew for further periods of the 10 years. It's the same in both India and Singapore. Let's look at some of the statistics in terms of patent applications filed in the home countries. In 2018, in India, 16,000 applications were filed, while in Singapore, it was 1,600. In 2019, in India, 19,000 applications were filed against 1,800 in Singapore. Let's look at the trademark applications numbers. 2018 in India, 324,000, it's a whopping amount. Singapore, 25,000. 2019, it's almost 350,000 in India, and Singapore, 26,000. Industrial design applications, 2018, it was 12,000 in India, Singapore, 2,000. And in 2019, India was 13,700 against 2,300 in Singapore. Last but not the least, geographical indications. In 2017, they're 305, then in 330 in 2018, and 361 in 2019. No GI applications were filed in Singapore during this period of time. Now let's quickly touch base on the MOU that was signed in 2016 between Singapore Intellectual Property Office and the Ministry of Commerce and Industry, Government of India. The main purpose or the main aim of this MOU is to establish a wide-ranging and flexible mechanism for developing and cooperating between the parties in industrial property field and information technology services related. Both countries have also signed other MOUs with different countries to increase collaboration and provide protection to IP creators. So now I'm going to move on to the concluding part. So in conclusion, what I would like to say is that in today's highly commercialized and innovative world, IP has acquired unprecedented importance, and issues relating to the generation, evaluation, protection, and exploitation of IP have become crucial. Changes in the global economic environment have influenced the development of diverse business models where IP is a central element establishing value and potential growth. IP protection goes a long way in IP commercialization and IP generation, and vice versa. Knowledge capital, which is the product of the intellect, has become an increasingly important basis of socio-economic and political cultural development. Therefore, we can rightly say that it is imperative to build a robust international regime and national IP ecosystems to promote and protect intellectual property. With this, I have come to an end of my presentation, and I'll pass it over to Ashif for the Q&A. Thank you.
Thank you, Kaushik. That was very interesting. Though a lot of technical terms, but yet I still learned a lot. In view of today's topics, I'm going to start off with the questions that we received this evening from the participants that is more related to India. So I have this one question from Mr. Boon Kiat, and he said, I heard that IP enforcement may be problematic in India because the court proceeding will take a long time. And how true is this since the development, and how many months or years will it take to initiate an IP infringement proceeding? And anything one can do to speed this up? So what is the cost estimate? So there's a lot of question within this one question.
Yeah, I'll take this up. So yes, I mean, you are right to an extent to say that it takes time in India to get the court proceedings completed. But as you can imagine, looking at the statistics that I just shared, there are innumerable number of applications every single year. So that means that there is likely to be a lot of oppositions as well. That means other parties who are probably opposing those applications, whether it's for trademark or whether it's for a patent. So in that situation, when it goes to the court has a long list of pending cases. So that's why it's not easy to get a decision or a judgment at the earliest possible time, and that's why it takes a lot of time to complete the proceedings. And they have to follow the procedures and the policies under the relevant statutes and the acts. So that's why it takes time to complete everything that is being prescribed for you to follow. And then in terms of the cost estimate, it's really depends. If you are engaging a top tier law firm, or if you're engaging like a single man attorney, then the cost estimate will be different. And in terms of the cost, the cost to the court, that means the kind of fees that you have to pay to the court or to the authorities, these are all prescribed amounts, so they cannot basically change this as per the situation. So those costs will be fixed, but in terms of your legal cost, it depends on the legal services that you're going to take in from India. And anything we can do to speed this up, I think that's a difficult question. I mean, one of the ways is that you can go and negotiate. You can negotiate and try to mediate with the infringer. What you can do is that you can ask them to cease and desist. That means to stop the infringement and pay you compensation for the past infringing activities. So there are different ways you can start mediation, or you can start talking about settlement with the infringer.
All right. So the next question I'm going to take has something in common. It has to do with digital. So I'll
Mhm.
take two questions and combine them into one from Sadish Kumar as well as a participant named IT. One of the questions is, what are some of the copyright and other IP issues that have come up as a result of technology? And the other one is, how are they protecting in the digital era? And what's the best way to protect the IP during the process of its creation? So
Yes,
it's
that's
two.
a very good question. So this is related to technology, right? So
Yeah.
when you are creating new technology, you can go for either patent protection, or you can also go for copyright protection if you're developing a software or a computer program. So in order to protect your IP, you should first of all do the registration in India. So, and to do the registration in India, you can follow different routes. You can either go through the international conventions, or those administered by WIPO, World Intellectual Property Organizations, or you can directly also approach the national office for registration and all. But the main point is that definitely there will be issues in terms of proving your claim of ownership, that in order to get your application successfully accepted by the authorities, you need to meet the criteria that have been prescribed by the authorities or under the copyright laws of India. So in terms of how you handle these issues, it will actually depend on quality of your intangible property, whether it's a new one or whether it's an inventive step of an existing one. So you have to really prove it to make it applicable and to make it registrable in India. And then only you can try to protect it. And you have to do some kind of IP management, or I'd say strategic management of your IP, so that you know at what point of time you're creating your IP, how you should go about protecting your IP, and how you can enforce your IP. So it really depends on the type of IP that you're looking at it. So if it's a copyright, it's different from a patent. So you cannot follow the same strategy for both copyright and patent, right? So, and similarly for trademark. So you really have to strategize. So, and that's why we have generally will get legal advice whenever you're setting up a company, or you want, or if you feel that you're going to produce a tremendous IP, then you should take precautions, or you should take precautionary steps in terms of doing the IP management strategy as well as protection strategy going forward.
So in view of time, we have about 5 minutes left. So I'm going to take last two questions. One is relating to something that is very common to many people. That's the YouTube. I'm sure everyone knows what's YouTube. So Samuel Lee asked, are YouTube videos protected by any IP? Example, if person B repost person A's video but misrepresent person A's intent, or commercialize person A video. So will there be any implications?
Yes, definitely. Your videos are protected by IP. So if someone is stealing your video or posting it as their own video, they are actually doing a copyright infringement, because they are saying that they are the owner of this copyright, which actually belongs to you. And if you actually report that to YouTube and telling them that you are actually the owner of that IP, then YouTube will definitely take it down. So in sometimes it's difficult in terms of providing the evidence, whether you are the owner or the other person is the owner, then you definitely have to show proof that it's the video was created by you and not by the other person. Because for YouTube, they would not be able to distinguish whether you are the actual owner or person B is the actual owner. But definitely this is also protected. Any YouTube videos that are posted by anyone will be protected by IP.
Okay. All right. One last question I will take is, it's kind of simple, but I think it's quite good to know. He asked, Mr. Balasubramaniam. So he asked, Is there any things or products that are excluded from IP or copyright and trademark?
No, to my knowledge, I don't think there are any things or products that are excluded from IP. So in order to get IP protection, as I said, you have to meet certain criteria that are prescribed under the applicable act. So if you're talking about copyright, so you have to be able to meet the prerequisites of the Copyright Act in order to get protection. So if you say it's a book, yes, you can get copyright protection. But if you say, can I have trademark protection over the book? No, you can't have. It's a book. It's a literary work. It is copyright protected. It's not trademark protected. But then again, you can say that the logo that is going onto the book, that belongs to McGraw Hill. Yes, that logo is trademark. So that can be protected under IP. So most of the things or most of the products that you have will be protected under trademark or copyright. But there are some concepts like, when the protection term of that particular IP has ceased, then it goes into the public domain. That means public can use it for their personal purposes, and other things for development or other work. So until that, protection period is there, others are not able to use it because you have the rights as an IP owner. But once it goes into the public domain, yes, then the public can actually come and use that particular product.
All right, on that note, thank you so much, Kaushik, for your interesting stories and insightful sharing. We really appreciate the time which you have taken today to share your first-hand experiences and useful information with us. And we hope that everyone enjoyed the session and gained deeper understanding of managing intellectual property in Asia and especially in India. But before we end the session, may we invite our viewers to scan the QR code seen on the screen or click on the link in the chat to the online survey form to help us improve our future programs. All right, thank you everyone for your participation today. We have come to the end of the program, and the next Eye on Asia webinar will be in July. Do look out for it. And also do visit the Eye on Asia website to learn more about the initiative. So to everyone, have a very good holiday eve and holiday tomorrow. Goodbye.